National Ownership Unit 6 Summary, Title and Title Transfer. Someone who possesses all ownership interests owns legal title to the property. Equitable title is the right to obtain legal title to a property in accordance with a contract between the legal owner and a buyer. Receiving actual notice means learning something through direct experience or communication. Constructive notice or legal notice is knowledge of a fact that a person could have or should have obtained. Transfer of title. When the transfer uses a written instrument, the transfer is the conveyance. Voluntary alienation is an unforced transfer of title by sale or gift from an owner to another party. Involuntary alienation is a transfer of title to real property without the owner's consent. Deeds of conveyance. It is necessary for the deed to be delivered to and accepted by the grantee for title to pass. In states that use the Torrens system, title passes only when the deed has been registered on the certificate of title and a transfer certificate has been issued to the new owner. Depending on state law, a deed must meet the following requirements for validity: be delivered and accepted, have a competent grantor and legitimate grantee, be in writing, contain a legal description, contain a granting clause, include consideration, be signed by the grantor, and be acknowledged. A deed without an acknowledgement tends to endanger one's claim to a property. Recording the deed gives the public constructive notice of the grantee's ownership. Conveyance clauses describe the details of the transfer. Covenant clauses present the grantor's assurances to the grantee. With statutory deeds, the covenants are defined in law and do not need to be fully stated in the deed. The prominent types of statutory deed are as follows: bargain and sale deed. I own but won't defend. General warranty deed. I own and will defend. Special warranty deed. I own and will defend against my acts only. Quitclaim deed. I may or may not own and I won't defend. A special purpose deed is one tailored to the requirements of specific parties, properties, and purposes. The principal types are personal representative's deed, guardian's deed, sheriff's deed, deed of trust, deed in trust, master deed, partition deed, patent deed, and tax deed. State law usually requires payment of a documentary stamp tax on a conveyance of real property. Exemptions include transfers within the immediate family or between government entities. Wills. A last will and testament takes effect only after the testator's death and is amendatory, meaning it can be changed at any time during the maker's lifetime. Commonly, the testator names an executor or personal representative to oversee the settlement of the estate. If a minor is involved, the testator may identify a guardian to handle legal affairs on behalf of the minor. Wills are generally one of the following types: witnessed, holographic, approved, and nuncupative. For a will to be valid, state law generally requires that the testator be of legal age and mentally competent, the testator indicate that the will is the last will and testament, the will be signed, the completion of the will be witnessed and signed by the witnesses, and the will be completed voluntarily without duress or coercion. A probate settles a descendant's estate, whether the person has died testate, having left a valid will, or intestate. Probate of real property occurs under jurisdiction of courts in the state where the property is located, regardless of where the deceased resided. If the will does not name an executor, the court will appoint an administrator to fulfill this role. Possible channels of probate deliberation, depending on whether there is a will and heirs: testate proceeding, intestate with heirs, and intestate without heirs. Involuntary title transfer. According to laws of descent, involuntary alienation occurs when a title holder dies without a valid will. Property that has been abandoned for a statutory period may escheat to the state or county. A property owner who fails to fulfill loan obligations or pay taxes may lose an estate through foreclosure. Various government and public entities can transfer private property to the public sphere by the power of eminent domain. An adverse possessor is someone who uses another's property without the knowledge of the owner, or with the knowledge of an owner who fails to take any action over a statutory period of time. To claim legal title, the adverse possessor must be able to show a claim of right or color of title as reason for the possession, have notorious possession, maintain a consistent claim of hostile possession, occupy the property continuously for a statutory period of time, and in some states, pay taxes. Estoppel prevents a person from claiming an interest that is inconsistent with the person's previous statements or acts. Title records contain a history of every parcel of real estate in the county. Important purposes of title records include public notice, buyer protection, and lien holder protection. Chain of title refers to the succession of property owners of record dating back to the original grant of title from the state to a private party. To remove the clouded title, an owner may need to initiate a suit to quiet title, which clears the title record of any unrecorded claims. Abstract of title is a written, chronological summary of the property's title records and other public records affecting rights and interests in the property. Each state prescribes procedures for recording in public title records: forms, proper execution, acknowledgement, and witnessing. In states using the Torrens system, the title passes only when the conveyance has been duly registered on the title certificate itself. Encumbrances, likewise, have no legal effect until they are recorded. Title evidence. To demonstrate marketable title to a buyer, a seller must show that the title is free of doubts about the identity of the current owner, defects, claims that could affect value, and undisclosed or unacceptable encumbrances. The principal forms of evidence the owner can use to support these assurances are a Torrens certificate, a title insurance policy, an attorney's opinion of the title abstract, and a title certificate. A Torrens certificate also acts as a deed of conveyance. The title and encumbrances are recorded on the certificate. A title insurance policy indemnifies the policyholder against losses from title defects. An attorney's opinion of the title abstract is a written statement from an attorney stating an opinion of marketability based on examination of the title abstract. A title certification is a statement of the condition of title as of the date of the certificate.